I was talking to a guest on the podcast the other day, and we got into this whole thing about squatting. It was one of those conversations that starts off in left field. We were talking about real estate or something, and boom, next thing you know, we're down this rabbit hole of squatters' rights. Turns out it's a way bigger deal than I ever realized. People are literally taking over other people's properties, and in some cases, the law is actually on their side. It's wild, man. We're talking about adverse possession laws. These things go way back, and they basically allow someone to claim ownership of a property they don't own if they live there long enough and meet certain conditions. It sounds insane, right? But it happens more than you think, and it's a real problem that's only getting worse. So buckle up, because we're about to dive deep into the world of squatters' rights. We're talking state by state, law by law, breaking down how these laws work and what they mean for property owners. All right, so let's kick things off in the Garden State, New Jersey. Now, New Jersey is known for a lot of things: pork roll, Springsteen, the Jersey Shore, but easy squatting laws? Not so much. In fact, New Jersey has some of the toughest requirements in the country when it comes to adverse possession. First off, you gotta live on the property for a solid 30 years. That's right, 3 decades longer than some marriages. And it's not like you can just camp out in the backyard and call it a day. You gotta be living there openly and notoriously, like you own the place. You're talking paying taxes, maintaining the property, the whole 9 yards. And here's the kicker: even if you do manage to jump through all those hoops for 30 years, you still have to go to court and convince a judge to grant you ownership. It's a long shot, my friends. New Jersey does not mess around when it comes to protecting property rights. So, if you're thinking about setting up shop in someone's abandoned beach house down the Jersey Shore, you might want to think again. This ain't your grandma's Jersey. Next up, we're heading over to the Buckeye State, Ohio. Now, Ohio's a bit more relaxed, shall we say, when it comes to adverse possession laws compared to our friends in Jersey. Don't get me wrong, it's not a free-for-all, but the requirements are definitely more attainable. In Ohio, you're looking at a 21-year minimum occupancy to stake your claim. That's still a significant chunk of time, but hey, it's 9 years shorter than New Jersey. And just like in Jersey, you gotta be living there openly, like you own the place. Paying those property taxes, keeping things tidy, you know the drill. But here's where things get interesting. Ohio has this thing called color of title. Basically, if you have a document, even if it's bogus, that makes it seem like you own the property, you can actually shorten that 21-year requirement down to a mere 10 years. Wild, right? So Ohio definitely throws a bone to those looking to acquire property the unconventional way. But remember, folks, even with slightly more lenient laws, squatting is still a gamble. All right, let's talk about the Windy City, Chicago, Illinois. Now, Chicago has its share of abandoned buildings, especially in certain neighborhoods. And with a large city comes, you guessed it, squatting. But don't think for a second that it's easy street in the heart of Illinois. Illinois throws up a 20-year roadblock for those looking to claim adverse possession. That's 2 decades of playing house before you even have a shot at owning the place legally. And just like other states, you can't just be a shadow lurking in the corners. You gotta be out in the open, acting like the rightful owner, paying taxes, mowing the lawn, the whole shebang. Now here's the thing about Chicago. It's a city grappling with urban blight and vacant properties. So, on one hand, you've got folks squatting out of necessity, finding refuge in abandoned buildings. But on the other hand, you've got property owners, many of whom are just regular folks, trying to protect what's rightfully theirs. It's a complex issue, man. And while those 20 years might seem like a lifetime, for some in the shadow of Chicago's gleaming skyline, it's the only shot they've got. All right, folks, let's mosey on down south to the Peach State, Georgia. Now, Georgia's got a bit of a split personality when it comes to squatting laws. See, they're currently in the midst of a legislative showdown over adverse possession, trying to tighten things up. Right now, Georgia's rocking that 20-year requirement to claim ownership through adverse possession. That's 2 decades of Southern hospitality, but not towards the original owner, if you know what I mean. And of course, you gotta be living there openly and notoriously, paying taxes, maintaining the property, the whole 9 yards. But here's the thing. There's a movement afoot to make it way harder to squat in Georgia. Lawmakers are trying to shorten that 20-year time frame, making it clear that they ain't messing around when it comes to property rights. So, if you're thinking about heading down south to set up shop in an abandoned pecan farm, you might want to check the latest legal rulings. Things are changing in Georgia, and not necessarily in favor of those seeking free rent. All right, let's swing over to the Tar Heel State, North Carolina. Now, North Carolina's got a similar vibe to Ohio when it comes to squatting laws. They're not as strict as some states, but they're not exactly rolling out the welcome mat for squatters either. Just like in Ohio, you're looking at a 20-year occupancy requirement to even think about claiming adverse possession. And you can't just be a fly on the wall. You gotta be living there openly, like you own the place, paying taxes, keeping the property in shape, you know the drill. But here's where it gets interesting. North Carolina also has that color of title loophole we talked about in Ohio. So if you've got some kind of document, even if it's as phony as a $3 bill that makes it look like you own the property, you can potentially shave that 20-year requirement down to a cool 7 years. So there's a bit of a legal loophole for those who know how to play the game in North Carolina. But let me tell you, messing with property laws is a risky game, no matter which way you slice it. All right, let's head up north to Massachusetts, the land of clam chowder and notorious squatting laws. You heard me right. Massachusetts has some of the most squatter-friendly laws in the country, at least on paper. It's enough to make your head spin. Here's the deal. In Massachusetts, you don't have to hide the fact that you're squatting. In fact, you have to be open and notorious about it. We're talking full-on, I'm living here now energy. And get this, you only have to live there for 20 years, paying taxes and maintaining the property to stake your claim. Now, I know what you're thinking, that's a long time. But here's the kicker. In Massachusetts, you can actually use the time that a previous squatter was living on the property towards your own 20-year requirement. It's like a weird, legal game of tag, but with real estate. So, yeah, Massachusetts definitely keeps things interesting when it comes to squatting laws. It's a state where history and, shall we say, unconventional living arrangements often collide. All right, let's journey over to the evergreen state, Washington. Now, Washington's known for its lush forests, its coffee obsession, and its ongoing battle over squatting laws. Here's the deal. Right now, you only need to live on a property in Washington for 7 years to claim it through adverse possession. That's right, 7 years. And just like in other states, you gotta be living there openly, paying taxes, maintaining the property. You know the drill. But here's where things get spicy. There's a major push to crack down on squatting in Washington. Lawmakers are trying to extend that 7-year requirement, making it harder for squatters to set up shop. They're also trying to close legal loopholes that have made it easier for squatters to slip through the cracks. It's a real tug of war between those who see squatting as a form of housing justice and those who see it as, well, straight up theft. All right, let's climb those Rocky Mountains and head to Colorado. Now, Colorado's got a long and storied history, from its gold rush days to its hippie heyday in the 60s and 70s. And that history includes, you guessed it, squatting. See, back in the day, Colorado was like the Wild West of squatting. People were staking claims on land left and right, especially in those remote mountainous areas. But things have changed a bit since then. These days, you're looking at an 18-year minimum occupancy to claim adverse possession in Colorado. And just like in other states, you gotta be living there openly, paying taxes, maintaining the property, you know the drill. But here's the thing. Colorado's got this interesting legal concept called hostile possession. Basically, you have to occupy the property without the owner's permission, and your presence has to be, well, somewhat hostile. All right, let's cruise over to the Motor City, Detroit, Michigan. Now, Michigan's a state that's seen its share of hard times, especially with the decline of the auto industry. And with those hard times comes, you guessed it, squatting. In Michigan, you're looking at a 15-year occupancy requirement to claim adverse possession. That's a long time to be living rent-free, but it's not exactly a walk in the park. You gotta be living there openly, paying taxes, maintaining the property, you know the drill. But here's the thing. Detroit, in particular, has been grappling with a surge in squatting in recent years. See, the city's been hit hard by foreclosures and abandoned properties, creating a perfect storm for squatters. It's a complex issue, man. On one hand, you've got folks who are just trying to survive, finding shelter in abandoned homes, but on the other hand, you've got property owners who are struggling to hold on to what's theirs. All right, let's head down to the Old Dominion, Virginia. Now, Virginia's got a rich history, from its colonial roots to its role in the Civil War. And that history includes, you guessed it, squatting. See, back in the day, Virginia was a vast wilderness, and people were settling wherever they could find land. And sometimes, that meant squatting on land that wasn't technically theirs. These days, Virginia's squatting laws are a bit more, shall we say, defined. You're looking at a 15-year occupancy requirement to claim adverse possession. And just like in other states, you gotta be living there openly, paying taxes, maintaining the property, you know the drill. But here's the thing. Virginia's got its share of forgotten cabins, abandoned homesteads, and properties with murky ownership histories. And those properties can be prime targets for squatters. It's like something out of a Southern Gothic novel, man. You've got these old, creaky houses with stories to tell, and you never know who might be lurking in the shadows, claiming them as their own. All right, let's head back to the Pacific Northwest, Oregon. Now, Oregon's a state of contrasts. You've got your lush forests, your rugged coastlines, your hipster havens, and your tech hubs. And with all that diversity comes, you guessed it, squatting. In Oregon, you're looking at a 15-year occupancy requirement to claim adverse possession. And just like in other states, you gotta be living there openly, paying taxes, maintaining the property, you know the drill. But here's the thing. Oregon's got a bit of a split personality when it comes to squatting. In rural areas, you've got folks squatting on abandoned farmland or in remote cabins. But in urban areas like Portland, you've got squatters taking over vacant homes or even commercial buildings. It's a reflection of the state's own internal struggles, man. You've got the old school, live off the land mentality clashing with the rapid gentrification and rising housing costs in the cities. All right, let's roll the dice and head to Nevada. Now, Nevada's known for its casinos, its desert landscapes, and its anything-goes attitude. And that attitude extends to some extent to its squatting laws. See, Nevada's got a bit of a unique approach to adverse possession. The amount of time you need to live on a property to claim it varies depending on the circumstances. It could be as short as 5 years or as long as 15 years. But here's the thing. No matter how long you've been squatting, you gotta meet certain conditions. You gotta live there openly, pay taxes, maintain the property, you know the drill. And you gotta prove to a court that you've been using the property as your own. So yeah, Nevada's squatting laws are a bit of a gamble. You might hit the jackpot and get away with squatting for a relatively short time. Or you might crap out and end up getting evicted. All right, let's head to the desert Southwest Arizona. Now, Arizona's known for its scorching heat, its stunning landscapes, and its surprisingly complex squatting laws. See, in Arizona, the amount of time you need to live on a property to claim adverse possession depends on how the land is being used. If it's being used for agricultural purposes, you're looking at a 10-year occupancy requirement. But if it's not being used for agriculture, it could be as short as 3 years. But here's the thing. No matter how long you've been squatting, you gotta meet certain conditions. You gotta live there openly, pay taxes, maintain the property, you know the drill. And you gotta prove to a court that you've been using the property as your own. So, yeah, squatting in Arizona is a bit of a mixed bag. It can be relatively easy to claim property if you know how to play the game. But it can also be a risky proposition, especially if you're squatting on someone's primary residence. All right, let's head up north to the last frontier, Alaska. Now, Alaska's known for its vast wilderness, its rugged individualism, and its surprisingly strict squatting laws. You might think that in a state with so much uninhabited land, squatting would be a free-for-all, but you'd be wrong. See, Alaska takes property rights seriously, even in the middle of nowhere. In Alaska, you're looking at a 10-year occupancy requirement to claim adverse possession. And just like in other states, you gotta be living there openly, paying taxes, maintaining the property, you know the drill. But here's the thing, Alaska's got a lot of land, but it also has a lot of people who are protective of their property. So even if you find a remote cabin in the woods, don't assume you can just move in and call it your own. All right, let's head back down south to South Carolina. Now, South Carolina is known for its beaches, its barbecue, and its surprisingly specific squatting laws. See, in South Carolina, you need to live on a property for 10 years to claim adverse possession. But here's the thing, you gotta be doing more than just living there. You gotta be cultivating the land or building on it. That's right, folks. If you're thinking about squatting in South Carolina, you better be ready to get your hands dirty. You gotta be tilling the soil, planting crops, or building structures. Otherwise, you're not gonna have a leg to stand on in court. So, yeah, South Carolina's squatting laws are not for the faint of heart. You gotta be willing to put in the work if you want to claim someone else's property as your own. All right, let's head over to the Keystone State, Pennsylvania. Now, Pennsylvania is known for its history, its cheesesteaks, and its surprisingly complicated squatting laws. See, in Pennsylvania, the amount of time you need to live on a property to claim adverse possession varies depending on the circumstances. It could be as short as 10 years or as long as 21 years. And to make things even more confusing, there are different rules for different types of properties. For example, there are different rules for vacant lots, abandoned homes, and properties that are being used for commercial purposes. So, yeah, if you're thinking about squatting in Pennsylvania, you better bring a lawyer with you, because navigating the state's squatting laws is not for the faint of heart. All right, let's head to the Empire State, New York. Now, New York's known for its skyscrapers, its pizza, and its surprisingly strict squatting laws. You might think that in a city like New York, where housing is scarce and expensive, squatting would be rampant. But you'd be wrong. See, New York has some of the toughest squatting laws in the country. In most of New York, you need to live on a property for 10 years to claim adverse possession. And just like in other states, you gotta be living there openly, paying taxes, maintaining the property. You know the drill. But here's the thing. In New York City, it's even tougher. The city has a fast-track eviction process for squatters, and you can be kicked out in as little as 30 days. So, yeah, if you're thinking about squatting in New York, you better think again, because the odds are stacked against you. So there you have it, folks, a crash course in squatting laws across America. It's a wild world out there, man. Who knew there were so many ways to legally take over someone else's property? But seriously, this whole thing just goes to show you how important it is to protect your property rights. Whether you're a homeowner or a landowner, you gotta be aware of the laws in your state and take steps to prevent squatters from moving in. Because once they're in, it can be a real pain in the ass to get them out. And nobody wants to deal with that, right? So be vigilant, be proactive, and don't let those squatters take over your little slice of the American dream.